So, the Special Immigration Appeals Commission, SIAC, fair enough? It's a simple question, but it conceals a devilishly complex set of issues. And this evening, over the next 90 or so minutes, we are going to try to attempt to answer it with the assistance of a selection of the Garden Court SIAC team. Stephen Clark will be reminding us, unfortunately, of the dramatic Supreme Court judgment of Begum. Emma Fitzsimons will introduce us to the currently fashionable basis of deprivation, involvement in serious organised crime. David Sellwood will try to crack the case of the mystery of the disappearing ECHR jurisdiction. And Amanda Weston will unlock the secrets of arbitrariness. But before I turn over the floor to them, I'd like to arrange the stage a little bit. We have to be careful to contextualize our question correctly. If we drop the word enough from the question and just ask the question, is SIAC fair? Then the answer is easy, is no. SIAC was set up under the SIAC Act 1997 and designed unfair. The SIAC Act is parliamentary sanctioned unfairness. It legalizes fundamental common law unfairness. What is that central unfairness? A person can appeal a decision to SIAC, but the specific allegations and evidence is withheld from the appellant and their lawyers. They don't get to see it. How do you defend in such a case? You can't. That's the unfairness. But what you could do in defending a case in SIAC is spend thousands of hours with your client desperately trying to guess at what the case is against you, and then spend another hundreds or so hours trying to put the evidence together of the case that you're guessing at, or multiple cases. Then you fire that evidence into SIAC and hope for the best. The metaphor is a blindfolded person aiming a shot at a target they cannot see. Is that fair? Obviously not. But it's at least a sporting chance. A chance to show SIAC a person is not a national security risk, in fact, and the Secretary of State has got it wrong. The SIAC procedure, in an attempt to ameliorate that inherent unfairness, offers up the special advocate system, where experienced advocates cross the closed threshold and they try to push closed evidence into the legal daylight and try to attack the closed case. But the attack is limited. It is only an attack against the prima facie case against the person. The special advocate can't provide the defense. They can't speak to the client. So does the special advocate system cure the unfairness? No. As a result, the spectre of innocent appellants who have lost their appeals haunt the SIAC basement. Unfairness is therefore in SIAC's statutory bones, knowingly written into its DNA by Parliament itself. So when one asks the question, is SIAC fair enough when it was created in 1997, one answer might be, well, yes, it is a balance between the ability of an appellant to challenge a decision taken on national security grounds and the need to protect the important public interest of national security. So for the purposes of this evening, let us assume this pleasant legal fiction that the operation of SIAC was fair enough at its inception. So how then can we test whether SIAC is now, 26 years later, Fair enough. We can apply the test that SIAC has applied to itself. The current chair of SIAC said in E8, a judgment from October of this year, both the Commission and the Court of Appeal have said on a number of occasions that the basic unfairness inhering in a procedure which relies on closed material to which the appellant is blind places an additional burden on us. In our view, meticulous care is required across the entire range of the Commission's functions under the SIAC Act 1997. In November of last year, Mr. Justice Ousley, a previous chair of SIAC, put it more widely when speaking about closed material procedures in general. He said the predicate for the closed material procedure is that its operation will be as fair as possible, consistent with its purpose. So let us look at whether SIAC, in context, currently operates as fairly as possible. We can draw the veil of charity, I think, over SIAC's indefinite detention without trial years and its deportation with assurances period and turn to an important year in SIAC's history, 2009, when it was determining the case of Al-Jeddah in a deprivation of citizenship case. Now, SIAC's chair at that time was Mr. Justice Mitting. The SIAC chair usually, a bit like Doctor Who, regenerates every 4 years. And he set the following approach in 2009 to deprivation appeals, and I'm going to read it out. An appeal, and that's my emphasis, an appeal is a challenge to the decision itself, not to the exercise of a discretion to make it. He therefore found the legislation therefore left SIAC free to, and I quote, decide what to do in the light of its findings. SIAC was therefore categorizing the approach as a full merits appeal, as we would traditionally as lawyers understand it, and sharply steered away from a judicial review or public law approach to a review of the discretion of the decision of the Secretary of State. He noted that nonetheless, in the context, one had to pay respect and apply Rehman and give due weight to the conclusions and assessments of the Secretary of State. He went on to say the principal issues on national security are invariably what has the appellant done and what inferences can be drawn from his past actions and current capacity and beliefs about the threat, if any, he poses to national security. These are matters of individual assessment, which the Commission is particularly well placed to make. Indeed, its procedures almost certainly ensure that the case of an individual appellant is subjected to greater scrutiny than could be given to it by the Secretary of State. We are accordingly uncomfortable with a hybrid approach which imposes constraints of uncertain extent upon our ability to determine an appeal on the facts found and assessments made by us. Further, when the issue is whether or not an individual should be deprived of citizenship, that issue depends significantly on past events. We too consider that fairness requires that we determine those events on balance of probabilities. We reject that an individual may be deprived of citizenship merely on the basis of suspicion, however reasonable, that he may have done something in the past which demonstrates that he may pose a threat to national security. So, this approach, set down in 2009, constituted the appeal process where the appellant could give the hidden target their best shot, and SIAC would decide whether they had hit the mark. Fair enough? In the circumstances, maybe. At least an appellant, in theory, could win. And so that approach lay undisturbed for 12 years, until Begum. But in those 12 years, There was no appeal by the Secretary of State that that approach that was being applied was wrong. There was no complaints in Parliament by successive governments that this approach was wrong or represented a misapplication of Parliament's intent when it had provided itself for a right of appeal. But before we get to Begum, there is another important development that was occurring over those 12 years. The Secretary of State started to deliberately deprive individuals of their British citizenship when they were outside the UK, as a simple way of ensuring they could not return, at least for the time the appeal hearing was extant. Our Amanda Weston was at the front of those first legal conflicts. And I can't do justice to the lengthy and difficult battles that she waged in this time. But the result was that SIAC developed a very high bar to whether a person needed to be inside the UK in order to have a fair and effective hearing, even where closed material procedures are being used against them. This led to the SIAC age of having to prepare very complex appeals and obtain highly complex evidence from appellants who were abroad, having been cut off from the UK, sometimes their family, and then having to provide oral evidence remotely from that country, if it was indeed possible to do that. To layer the analogy, the blindfolded person was now seeking to hit the target, not in the same room, but from a different country. The extraordinary difficulties that can occur when one is trying to prepare an appeal in those circumstances cannot be overstated. Fair enough? Maybe not by this stage. Nonetheless, in February 2021, the case law allowed for a very narrow pathway for an appellant called P3 to successfully argue in SIAC that he should be allowed entry to the UK to ensure his deprivation appeal was fair and effective, i.e. he would attend in person. SIAC agreed that P3's very poor psychological state meant that the fairness requirement under Article 8 meant that he had to be present in the UK to prepare and present his deprivation appeal. SIAC also applied the usual test in relation to the alleged national security risk, i.e. it decided for itself whether there was such a risk. It found in that case the risk was very weak against, the national security risk was very weak in P3's case and did not outweigh the desperate need to reunite him with his family. So P3 won. And that feels like a long time ago, because days after that successful judgment, Begum was handed down and the Secretary of State appealed P3. So if P3 represented the end of Star Wars, a new hope, the hand down of Begum was certainly the Empire Strikes Back. And on that overly dramatic note, I'm going to swap seats with Stephen.
Thank you, Ed, for doing the kindness of not playing the Imperial March as I rose to speak, but it may actually in some ways be appropriate for what I'm about to discuss. Begum's, of course, a bit of a difficult subject to grapple with, when many of you will have been very familiar with it, not just from an initial hand down, but in having to grapple with its consequences since in both SIAC and the tribunals, but undoubtedly having heard many learned counsel, much more learned than me, talk about it many times before. And what I hope to do is something a little bit different, in the sense that what I want to do is to connect Begum to SIAC's past and demonstrate how the Supreme Court in Begum tries to present it as a continuation, that the judges in the Upper Tribunal in SIAC took a wrong turn over the intervening years, and actually this was the true position. But also to demonstrate in how it went about that task, it made many of the consequences we're now grappling with, not just in the national security context, but in the context of fraud and the serious organised crime context that Emma's going to speak about, inevitable. As an advocate, you often leave court, and particularly the senior courts, engaging in a bit of an exercise of criminology. Except rather than looking at Red Square and the changing of the guard and wondering if the Cold War's about to break out, you are overanalyzing that twitch of an eyebrow halfway through your submissions and wondering if that means whether you won was the case. There are some rare moments, though, where you can tell, sometimes in retrospect, where the case was won or lost and where the outcome was determined. And I think Begum is one of those cases. I have the striking memory in James Eady's reply, Sir James Eady's reply, that Lord Reed rose his head and said words to the effect of, "This all turns on Rehman, doesn't it?" And if you read the judgment, it requires some quite careful reading, because it's not the best structured judgment in the world. Bold statement, I know, but it does in the end. And certainly I think the intellectual edifice of the judgment does. But should it? How did we reach the position whereby the very first case to come out of SIAC ended up determining the scope of the jurisdiction in 2021? Not only that, how does it then feed into the question of fairness? And it's worth remembering in Begum, and perhaps when you are reading Lord Reed's judgment, that it is worth reasoning backwards and from the successful appeal in the Court of Appeal in respect to the leave to enter application. If you are to determine that it is unnecessary for someone to be admitted to the United Kingdom for a fair hearing of the appeal, one way to go about achieving that is to redefine the nature of the jurisdiction and therefore the considerations of fairness to become very different. If you pick up the judgment, it's not framed as being in two parts, and that's why it makes it very difficult, and that is what has given rise to a lot of the difficulties elsewhere, and certainly some of the issues Emma will come on to speak about. But it is in some ways in two parts, in my view. The first is a textual analysis of the statute. What is the nature of SIAC statutory jurisdiction as it stands today? Before then moving on to the national security context. Now that's my nice breakdown of perhaps how it should have gone about its task. But it's blending and it in fact bounces backwards and forwards between those considerations as it works through its judgment. But in order to start off, and I think in what they were trying to achieve, or what Lord Reed was trying to achieve, is to say that effectively there is a blank slate in respect of the unrestricted general ground of appeal that exists under the British Nationality Act. And in order to say there is a blank slate, Lord Reed begins by stripping apart large amounts of the Upper Tribunal's judgments in Delalassie and BA. And you can start to see the warning signs when he lands on CMG Ockelson's statements in Pizzado, where he makes the point, well, the language that is in section 42 and section 43, i.e. conducive to the public good and the fraud case, are all addressed to the Secretary of State is satisfied. And your first alarm bell begins ringing there, because there is no mention of the fact that that same language is repeated in section 44 in respect of statelessness. The precise language is the Secretary of State may not make an order under subsection 2.2, under subsection 2, if he is satisfied that the order would make a person stateless. Now, it is, to this day, still the same position that statelessness is to be determined by the tribunal or the court on appeal. It is not restricted according to the Secretary of State's view. It is not whether the Secretary of State reached that view reasonably, whether it was open to them on a public law analysis. It is a full fact and merit question for the tribunal or for SIAC. That doesn't even get mentioned, let alone addressed. And if you're engaging in a serious textual analysis, you are going to have to grapple with that head on. And indeed, that's a point that Mr. Justice Jay, the current chairman of the Commission, has made in E3. And it continues in the same vein, identifying a series of tax tribunal cases and explaining why the tax tribunal is largely done on sometimes what tax practitioners refer to as a super JR basis, covering the wide range of reasonableness. But what there isn't any consideration is that the question of a general ground of appeal, i.e. Parliament has provided for a right of appeal to a tribunal without specifying the grounds, is in fact common in other areas, including saying that it is for the first instance decision maker to do so. That same language exists in respect to the social security tribunals. where, again, there is no question that the social entitlement chamber of the first-tier tribunal can reach its own views on the evidence and reach a view on the application of the system in terms of whether someone is entitled to disability living allowance, personal independent payments, or the disability elements of universal credit. There's no consideration even of the Supreme Court's own case law, and very recent case law, for example, in SIAC, which deals with, again, a general right of appeal from the GMC to the Medical Practitioners Tribunal Service without specifying that in any narrow nature. And in SIAC, the Supreme Court was very clear, well, that means it's a full fact and merit jurisdiction in order to deal with certain provisions of the Equality Act. And it also doesn't put many of these statutes into context and overlooks a very important principle of administrative justice in the tribunal system. Many of these tribunals, before they became the first-tier tribunal, existed as an extension of the decision-making process. They existed as quasi-judicial bodies within their, what were called sponsoring departments. The idea that you had a restricted right on public law grounds didn't exist in relation to first instance appeals from the decision maker. It was about what happened after your first appeal, what the scope of the second-tier tribunal would have a look at. And as I say, once Lord Reid has gone through these to say, well, actually, we have a bit of a free hand in terms of what the scope of that appeal should look like, that is where Rehman starts to bite with full force. And of course, because it's the first case and the oldest case, its language exists in a bit of a vacuum now. Lord Hoffman's paragraph 54, which becomes the linchpin upon which the judgment in Begum turns, has ended up being quoted to the extent it's almost done completely out of context. If you go back to SIAC's judgment, what were the questions that SIAC in Rehman was actually dealing with? It was actually two related questions. It concerned a gentleman called Shafiq Rehman. And the allegation by the time it reached SIAC was that he was the UK point of contact and the fundraiser for an organisation called Markaz Dawa al-Irshad and their armed wing, Lashkar Tayaba, which were specifically concerned with the conflict in Kashmir. The argument that Mr. Rehman was running at first instance was actually twofold. The first is, well, actually, I don't have any relationship, I'm not factually involved with the actual armed activities that take place in Kashmir. He was running what would go on to be called the factual aspect, or factual question. But his advocates went further. There was an extensive argument at first instance that the definition of national security, and it was a question of controversy, should it be a narrow one or a wide one? And in SIAC's resulting judgment, it answered that it was going to be a narrow definition, so that the definition of national security should be construed narrowly. Accordingly, a person could be said to offend against national security if he engaged in, promoted or encouraged violent activity which was targeted at the UK, its system of government or its people. This included activities directed against the overthrow or destabilisation of foreign government. But it's the next bit which is critical, likely to take reprisals against the UK affecting the security of the UK or its nationals. That is an inherent policy question rather than necessarily a factual question. And that is indeed the way that ends up being dealt with by SIAC itself, but also once it reaches the Court of Appeal. It was never the proposition by the Treasury Council in Rehman, which is one Mr. Philip Sales, who I don't know what he's gone on to do, but Eleanor Sharpston QC as well. They were never contended that SIAC couldn't address that first question. Was Mr. Rehman actually involved in these groups in the way that the security services alleged? That was always a question that SIAC could address for itself. And when it reached the Court of Appeal and indeed the House of Lords, that factual question was addressed. And again, it was always said repeatedly by Lord Wolfe that it was for the Commission to perform its primary task of assessing the evidence and making findings as to whether the applicant has engaged in or supported such terrorist activities, such that he can indeed be assessed to be a threat to the national security, part of the factual aspect. That was not the basis on which it went to the House of Lords. The basis on which it went to the House of Lords was the definition of national security, could SIAC decide that for itself, and a question about the standard of proof and the question of what amounts to a danger. And Lord Reid is reaching back to this, and that's the context in which Lord Hoffman makes his comments in paragraph 54. It is not dealing with the question of, you are alleged to have engaged in this kind of activity. You have gone and voluntarily aligned yourself with ISIL, or that you were acting on behalf of a foreign power and foreign security services. It is about that wider definition of national security. And indeed, again, when we come to paragraph 54, which Lord Reid then draws from that passage in Lord Hoffman's judgment to say, this is the basis on which SIAC exercises its section 2B jurisdiction, he doesn't go back and identify that actually that paragraph 54 is just a summary of Lord Scarman's judgment in the Council of the Civil Service Unions case, which in turn was actually just summarising very old case law, including the Zamora, which was a prize ship case involving the First World War. And once you start to, and yes, I am the kind of sad person who checks footnotes, that may have already become clear. The Zamora was, at the time of the height of the First World War, something that we often overlook a huge amount of, and actually the first wave of national security being raised as an issue, an immense amount of paranoia that led to the enactment of the Official Secrets Act. But even at that point, there was a question of, well, is this ship actually a prize ship? It was in the service of Germany. Even in that context, where we are facing a world war, or the Great War as it was then, the court still said it had to be satisfied on evidence that it was actually the case. The Zamora actually ended up being declared it isn't a prize ship, it could be released. It made comments about the nature of national security is to be determined by those responsible for it. But when it came to the factual aspect, and again, that is an issue which has been repeated throughout the older authorities, it was always an issue that the judges could address. Again, never addressed by Lord Reid on its face. Instead, we have this edifice of paragraph 54 in Rehman being elevated to the entire extent of the jurisdiction. And in doing so, it's also worth pointing out all of those other points that Lord Hoffman goes on to make about deference, judgment, and accountability. All of those comments are being made on a matter of very high policy. Is the conflict in Kashmir and terrorist activities on the territory of Kashmir, which don't directly affect the United Kingdom, against the interests of the United Kingdom national security? That is not granular factual detail, allegations made against your client, things that your client may have a response to. That is at its very highest level, and where, on a classic basis, the lightest touch judicial review principles may apply, even in a context where SIAC otherwise has a very broad jurisdiction. But equally, none of it deals with, and none of it tries to grapple with, and Lord Hoffman doesn't address, quite rightly, because it's not before him, and it's not the issue he's addressing, any of the questions of fairness about having a situation where a client needs to answer those critical questions, where they're out of the jurisdiction and unable to give effective instructions. But equally and importantly, it doesn't deal with the question of human rights. And indeed, Lord Reid seeks to step around that question, because he repeatedly emphasises in Begum that the question of a different approach on human rights is effectively lex specialis. It's again another sui generis issue. A different judicial approach will apply once you're into the realm of human rights. And that's of a part with his own judgments in Hesham Ali and the deportation cases that follow, emphasising the very different nature and the very different judicial function that exists under the Human Rights Act. Now you will hear in a moment, and I think I'm coming up bang onto time, instead complimenting himself, that you will hear David pick up as to why, in fact, on a practical level, that may, in fact, turn out not to be right, but also that the way it's being interpreted in SIAC today is that the two streams have, in fact, become blended together, so that there is no difference between a human rights appeal and an ordinary deprivation appeal. On that note, I'm going to hand over to our next speaker, which is Emma Fitzsimons, who's going to tell us about the exciting issues of serious organised crime.
Sorry, Stephen missed his mark there. But thank you, Stephen, for that very detailed analysis of Begum. But when Begum dropped, SIAC had to then interpret it. And what SIAC did with the number of cases that were before it in the deprivation appeals, it essentially interpreted Begum as it needing to apply a public law approach. Lord Reid said the principles to be applied are largely those of administrative law. So that's what SIAC set about to do. And in those case management appeal hearings, SIAC appeared to adopt a very strict JR approach, to the extent that it was not happy to accept evidence from the appellant that the appellant produced after the decision itself, applying a full JR approach, as if it was in the administrative court. Now, obviously, that had massive implications for fairness, but that was what was happening. In the meantime, P3, you remember the case that won, was being appealed up to the Court of Appeal, and the Secretary of State won. It was remitted back to SIAC. But before they sent it back, in a postscript, they said they balked at what SIAC was doing in terms of applying this strict JR approach, and stated in terms that SIAC could take into account any evidence it wanted, and it could make of that evidence what it may. So on the hanging on those sentences, when I was in front of SIAC, in U3's case, a substantive deprivation appeal, I was able to argue that SIAC should take into account all of the evidence that U3 had provided in answer to the national security case. So in U3, SIAC was confronted with a different problem. Obviously, it was unfair to ignore the hundreds of pages of evidence going to the point specifically that U3 was not a national security risk. So what SIAC had to do was somehow admit that evidence, which it did on a fairness basis, but as it veered towards the appellate structure, the traditional appeal approach, it then veered back. It admitted the evidence, but then said, I'm now going back to a public law approach because that's what the Supreme Court in Begum said we must do. Now that is where things go wrong in SIAC, because SIAC was confronted with a very difficult issue. In Begum, the Supreme Court was telling SIAC, you know that appeal DNA that you're used to applying, you must overwrite it with public law principles, but the two just do not sit together. They are not compatible. So SIAC had to find a way of moving through that. Its solution was to admit the evidence, but then apply a public law approach and declare that it was not making findings for itself on the basic building blocks of the national security case. So it was veering away from the traditional appellate approach that we understood. And I'm going to read out what SIAC summarized the position to be. The law allowed the Secretary of State to deprive U3 of her British citizenship on national security grounds. 1, without giving her the opportunity to show before the decision was taken that she does not pose a risk to national security. 2, without requiring the Secretary of State thereafter to prove, even on the balance of probabilities, that she does pose such a risk. And even more shocking, 3, without giving her the opportunity to persuade an independent tribunal that she does not constitute a national security risk. The very antithesis of an appeal. SIAC dismissed the appeal. Not surprising. If SIAC could not assess the evidence for itself and make findings for itself, and was only assessing whether the Secretary of State's analysis of the evidence and decision was flawed on judicial review grounds, then it is easy to see how difficult it is for an individual to win their case. To layer the analogy further, the blindfolded person now tries to hit the target from another country while riding a horse. It's that difficult. One might think that in relation to the test of whether SIAC operates as fairly as possible in national security cases, we may well be well south of that test. But soon after U3 and SIAC heard the case of D5 to D7 was not a deprivation case on the basis of national security, but on the basis of alleged involvement in serious organised crime. And now I'm going to hand over to Emma on D5, D7.
Good evening, everybody. I'm going to focus on serious organised crime. And without throwing another analogy or metaphor at you, which I think we as lawyers are very fond of, when I was coming to prepare for this topic, I was trying to describe what it feels like is the intrinsic problem. And the closest thing that I could grapple with is the idea that nature abhors a vacuum. So the idea that nature doesn't like empty spaces and it will try and fill them. And for me, I think that there's something analogous with the rule of law, that the rule of law doesn't like the idea of very broad statutory powers being exercised without any regard to material considerations either mandated by statute or by case law, and with very limited judicial oversight. So my thesis for this topic is that the rule of law, just like the rule of physics, abhors a vacuum. And just at the outset, I wanted to make 2 points about impact of deprivation, which will obviously be very familiar to everyone here. But the first point is the right to citizenship is obviously a fundamental right. And the Supreme Court, in the case of O, which was a case dealing with the citizenship fees regulations for children, pointed out that the right itself confers a multitude of other rights. So you have your right of abode, your right to a passport so you can come and go unhindered, your right to belong to a community, your right to participate in political process. So it strikes the very fundamental nature of a person's right to be a citizen here, really, in the UK. And the second point I just wanted to flag, which interestingly was picked up in the last week on a podcast I was listening to, and again is very familiar to many in the room, is the potential for discriminatory impact. And in particular, it was Baroness Worsey, who was a former Conservative Minister for Faith and Communities, who said on the Leaders podcast, "We now have a second-class version of citizenship. My children and your children could commit the same crime and my children could have their citizenship stripped because their great-grandfather left a country somewhere, a country they may never know, may never have visited, have never taken up citizenship, but because there is a rare potential probability or possibility that they are entitled to a second citizenship." And I think that's quite timely criticism from a former Conservative minister who has particular expertise dealing with communities to point out the potential discriminatory problems, especially when we come to look at serious organised crime cases. Stephen's very helpfully outlined the problems with the Begum judgment in the Supreme Court. So if I can just briefly move on then to look at why it's particularly problematic for serious organised crime cases. Ed's already referred to the fact that prima facie, it appears we are limited to a public law standard of review in those cases. And in addition, we are confined to what was advocated previously in the Rehman approach. But that doesn't easily map on to serious organised crime because crime is inherently different from national security. Crime is something that the courts are very familiar with dealing with. The courts are competent to make findings on balance probabilities, balance of burden of standard proof, and even in the criminal context beyond reasonable doubt. And so the notion that we should have institutional deference, particularly to an assessment by the Secretary of State in the criminal context, I think poses some normative problems in terms of the justification. So then what does fill the space in which the Secretary of State exercises her powers in serious organised crime cases? There are two very limited comments in policy. The first is the Chapter 55 policy, which really in the main is silent on deprivation in serious organised crime cases. And Interestingly, in the fraud cases, it gives quite detailed guidance about the process that caseworkers should follow and the approach to the assessment of evidence. If you look, by contrast, at where serious organised crime is mentioned, it's briefly just mentioned as a justification for deprivation. So no guidance at all as to how caseworkers should assess evidence, how to approach the question of weight, reliability, etc. Belatedly, in the last year, there's been publication of further guidance, and it's the deprivation of citizenship policy, which was published in May of this year. It's been updated already in October. And it deals in a little more detail with serious organised crime, but not much. And essentially, it flags that the justification for using immigration powers in the context of serious organised crime is because the government, in its 2018 National Crime Strategy, committed itself to disrupting organised criminal gangs. But much of the policy is silent, unhelpfully, as to how it's applied in practice by caseworkers, and much of it is restricted. And what the policy does not identify is how the Secretary of State is supposed to discharge the burden of proof in the serious organised crime case. It doesn't identify if there's a priority in conviction or non-conviction cases. It doesn't identify how the evidence should be considered. So there's no consideration of reliability, weight, matters of contentious evidence, so things like hearsay, previous allegations that may have been NFA'd, and previous convictions that may not seem material on the face of it. And then finally, there's no guidance to caseworkers as to what their duties of inquiry or disclosure might be in that context, which is very different, obviously, from the criminal context, where there's a duty constantly on the CPS to be reviewing the case in terms of fairness and whether or not it can even withstand the full code test. And so I would suggest that this policy itself is not much help in public law terms to understanding how we can see a fair exercise of power in the deprivation on serious organised crime grounds. And I also think that it's no answer from the Secretary of State to suggest that's because in that context, the power is entrusted to her personally and not her officials. And I say that for three reasons. First of all, ministers will invariably act upon the recommendations of their officials. And so the officials need to be advised what is the process for evidence gathering and making that recommendation, bearing in mind the inherent fairness that's already built into the system as Ed's identified. Secondly, in public law terms, the ministers are supposed to be accountable for the use of broad discretions, and that's especially so, I would submit, if you're departing from the notion that criminal allegations need to be established beyond reasonable doubt. And then finally, the overarching point that runs through this discussion is that deprivation on grounds of criminality is fundamentally different from deprivation on the grounds of national security. As I've already said, national security by its nature is entrusted to the executive in terms of its competence. But the courts and the judiciary are well equipped to deal with assessing evidence of criminal allegations. They do it day in, day out. And that doesn't offend against what Lord Hoffman says in Rehman about the twin principles of democratic accountability and institutional competence. And so for that reason, I'd say that the policy doesn't provide much comfort to those who are wondering how do we fill that vacuum. I'm going to now move on to talk about the case of D5, which Ed's already flagged, which was one of the serious organised crime cases SIAC dealt with last year. And that judgment was handed down a few weeks ago and it's available on the SIAC website. And it involved the deprivation and exclusion of 3 Afghan nationals who were accused of being involved in serious organised crime, in particular trafficking of children and vulnerable persons. They were all out of country at the time of the decision, and so they were outside, according to SIAC, the jurisdiction of the ECHR that it's going to come on to deal with. And I just wanted to highlight 3 aspects of the case where I think the facts starkly demonstrate the deficiencies of the Begum approach in this context. The first is that the underlying assessments that were relied upon by the minister do not contain any particularised allegations of criminal conduct, nor were there any assessments identifying even potential victims of the alleged criminality. And for those that do trafficking, that's highly unusual and quite suspect that you wouldn't even see NREM referrals, for example, or safeguarding measures by local authorities and police. And indeed, the second point to pick up on that is that SIAC itself never made any core factual findings because it wasn't assisted by the minister in understanding what the core allegation was. And so SIAC considered instead whether the assessments in and of themselves were simply sufficient in public law terms to invoke the power, even though it was established, and it's recorded in the judgment, that there are numerous factual problems with the assessments and that there were material matters on which the minister was misled. And in an ordinary public law context, you might think that's sufficient to get quash. But unfortunately, because we can't see the closed material, SIAC says, well, what we've seen in closed answers the problem of what's in the assessments in terms of the errors. And then finally, obviously, the inherently unfair point is that the individuals will never know what the key case was against them because it wasn't closed for that reason. And it's also just worth being aware, if you are reading the D5 judgment, that it was promulgated prior to the Secretary of State's policy that was published this year. There is an interesting discussion in the judgment as to whether or not a ministerial submission could amount to a statement of policy. And if so, why the Secretary of State departed from that policy by relying upon deprivation in a non-conviction case, and also with what appeared to be no material considerations as to allegations, evidence, burden, standard of proof, thresholds, etc. So one is left with a very unsatisfactory outcome and an intrinsic sense of injustice that the power to deprive has been effectively exercised in a vacuum with no effective legal policy or judicial oversight. And so finally, I turn to whether or not it's possible, bearing in mind the question, is SIAC fair enough? Is there scope for an alternative approach? It would be my position that the rule of law would require a vacuum to be filled with, first of all, a starting point that the Secretary of State publish in her policy how she intends to exercise her powers in a serious organised crime case outside of national security. Secondly, that assessments relied upon by ministers be robustly particularised, supported by evidence where possible, applying a coherent analysis of the standard of proof. And then finally, SIAC should, as advocated in U3, which Ed's going to pick up on, go on to make its own factual findings on the balance of probabilities if it's going to determine that it's a sufficient basis to deprive. Thank you very much.
Well, thank you, Emma, for that, demonstrating that the restricted approach in Begum is now leaking out of the national security box in which it was created in Rehman and into other elements of conducive to the public good, including serious organised crime. Now, when the draft judgment of D5 was sent to the parties to make the typographical corrections, U3 in the Court of Appeal dropped in July, meaning that we had to do submissions before the judgment was handed down in D5 to D7. Unfortunately, SIAC did not think that U3 assisted us in any way and didn't alter its judgment. Now, coming to U3 in the Court of Appeal now, is it Return of the Jedi? No. There are some positive elements to it. Trying to work out what they are and grasp onto them is extremely difficult. And every barrister that I speak to seems to interpret it differently. So I'm unusually, and particularly given the time, I'm not going to, as a barrister, speak to it. I'm going to ask, because we're very lucky to have Mr. Chris McKendry, who was the solicitor in U3, and ask his view or his take home of what U3 says.
I'll put me on the spot here. On one reading, like the Court of Appeal is a win. In theory, simply because we've got it in terms of and as a fact that are relevant to the national security assessment can be made, but they're also couched in these terms of appropriateness. It can make findings of fact, but should it? That's a question. And so I remember in the hearing, one of the very obvious examples is, well, SIAC can definitely find you not credible. SIAC can find lots of negative facts. And this is sort of put in terms of maybe suggest that the appropriate facts that SIAC could find would be the facts that you're not credible, that you did do something as alleged, perhaps in the assessment. And I would worry that the Secretary of State would attack anything that lent in the favour of the appellant as wandering into the realm of inappropriate, because it was steering too close to the shoes of the Secretary of State. So on one reading, the Court of Appeal judgment is helpful, but I'm feeling quite pessimistic about what the Supreme Court may or may not say it actually means.
Yeah, exactly. One of the big take homes was the reversal or the rejection of the Secretary of State's position. SIAC can't make findings for fact for itself. It now can. The question is what it should do with them. And unfortunately, U3 does not really answer that question in a national security case. And instead of providing a template for SIAC to look at new cases and apply a consistent and straightforward approach, it looks like that hasn't been achieved. So hopefully the Supreme Court may be able to tell us how to reconcile a public law approach with thousands of pages of evidence which go directly to whether a person is a national security risk or not. Essentially ask the Supreme Court again, what did you mean in Begum? So while that was all going on, the Court of Appeal has also been developing its jurisprudence this year in relation to whether Article 8 applies in deprivation appeals at all. And on that point, we go to David.
Thank you very much, Ed. I'm going to focus on two Article 8 issues in the time that I've got. First, whether Article 8 is engaged in a SIAC appeal against citizenship deprivation. And second, if so, what does it look like in substance? Both issues, as Ed said, were addressed by the Court of Appeal recently, in my case of R3, and by SIAC in Amanda's case of E5, and Ed's and Emma's case of D5. The headline point from those is that Article 8 is not engaged where an individual is deprived of citizenship whilst outside the country, unless they subsequently apply for entry clearance. And even then, it's a question of fact as to whether or not there is engagement. Neither R3 or D5, or indeed D5, are the last word on those issues, I'm sure. Why is it an issue? Why is Article 8 important? Well, for a number of reasons, many of which are obvious, but I've picked two. First, because Article 8 can be a key issue in a deprivation case, particularly where an individual's entire life, or much of it, has been based in the United Kingdom, where there is significant, substantial private and family life. Second, as already has been touched on, because in the Supreme Court, in Begum, a clear distinction was made between the role of SIAC when considering a decision to deprive, broadly through applying public law principles, and the wider assessment required when determining whether a decision violates Article 8. Although, as we've already heard, and as perhaps I'll touch on in a bit more detail, those distinctions have been marginalised, arguably, to a non-distinction. So, first, Article 8 engagement in deprivation appeals. ECHR jurisdiction is a good place to start. There are a number of cases on point domestically and in Strasbourg. I'm going to touch on a few of them. First, the Strasbourg case of Alskany and the UK from 2011, which reiterated the starting point, or the traditional view, begins with Article 1 ECHR. The ECHR requires contracting states to secure rights within the Convention, within its own jurisdiction. Strasbourg reiterated that jurisdictional competence under Article 1 is primarily territorial, and that acts performed in or producing effects outside their territory can constitute an exercise of jurisdiction within the meaning of Article 1, but only in exceptional cases. And whether a case is exceptional is a question of fact. In Abdul Wahab Khan and the UK from 2014, Strasbourg concluded that an out-of-country right of appeal to SIAC did not constitute a basis for establishing Article 1 jurisdiction. Articles 2, 3, 5 and 6 ECHR were deemed inadmissible on jurisdictional grounds where a person was outside the territory. But the court accepted, importantly, that Article 8 may, in some circumstances, require family members to be reunited with relations living in that state, in light of a positive obligation resting in large part on the fact family members were already in a contracting state and being prevented from enjoying family life because a relative is denied entry to that state. And we see that principle from a line of authorities going back to Abdul Aziz and the UK from 1985. Ultimately, the Article 8 element of the Khan case was deemed manifestly ill-founded or inadmissible because national security allegations against him were proven in SIAC, and there was relatively limited private life on the facts, meaning that the Secretary of State's exclusion decision against him was deemed clearly proportionate. Then we move on to the case of K2 in the UK, which followed in 2017. That's an important case, perhaps the only deprivation claim from Strasbourg, I think, where the court has considered the merits of an Article 8 claim against deprivation where the applicant was physically outside the UK at the time they were deprived. That claim also was found to be manifestly unfounded on the facts, but it was accepted that exclusion from the UK interfered with the applicant's private and family life. The question of jurisdiction was not directly addressed, presumably, perhaps, on the basis that both parties in that claim accepted it was in play. Other Strasbourg cases addressing citizenship deprivation and Article 8 appear to have concerned applicants who are in the country in question at the time, or at least were when the decision was made. That may well be because other European countries generally tend to deprive people or their individuals when they are in country, rather than when they are out of the country, which, as we've heard, is a recurring UK practice. I'll return to the principles of those other cases as set out more widely, but before I do, just sticking with the wider line of cases concerned with Article 8 jurisdiction when an individual is outside the UK. The Court of Appeal in Abbas in 2017 summarises the position. That case concerned a Pakistani national who applied for entry clearance to visit his elderly relatives in the UK. The application was refused by an ECO, but allowed on appeal by the First and Upper Tribunals on private life grounds. Reviewing the authorities, including Khan, the Court of Appeal concluded that the tribunals were wrong to allow Mr. Abbas's appeal because private life could not be relied upon to impose a positive obligation on the UK to admit somebody into the UK. In contrast, family life under Article 8 was unitary, so where family members are within the jurisdiction and an individual is seeking entry to join them to establish or continue family life, that creates what the Court of Appeal described as the jurisdictional peg for the purposes of Article 8. Much of what I've just said was recently rehearsed, as Ed said, in the Court of Appeal in the case of R3. R3 was a British citizen who travelled to Syria during the Arab Spring. He was subsequently deprived of his citizenship on non-conducive grounds, the Secretary of State concluding that he had aligned himself with an al-Qaeda-aligned group in Syria. SIAC concluded, and the Court of Appeal upheld, that Article 8 was not engaged, despite the fact he had family members, including British citizen children in the UK, and that was because he was outside the jurisdiction when the deprivation decision was made. The jurisdictional peg in Abbas was found not to have been engaged on the facts, but further still, the court concluded Article 8 would only ever be engaged if an individual formally seeks entry clearance to enjoy family life with family members here. Being deprived and prevented from returning to your country of nationality was not sufficient in and of its own to engage Article 8 if it occurred whilst the individual was outside the country of nationality. The thinking behind this arises in part from a particular way in which Strasbourg has substantively considered Article 8 in deprivation cases, which is the second issue which I'll briefly turn to. But just to finish on the issue of jurisdiction engagement, as I said, R3 and E5 and D5 now are unlikely to be the last word on point. 3 points to very briefly think about in the meantime. First, why does someone have to apply for entry clearance to potentially engage Article 8? By challenging a decision to deprive from overseas, you are specifically challenging the decision to refuse you entry as a citizen. If you win your appeal and retain British citizenship, you can come and go, of course, as you wish. Isn't an entry clearance application bound to be refused by an ECHR in any event? The very reason the Secretary of State deprives someone whilst outside the UK is, at least in part, to prevent them from returning. So to require a further application arguably puts form over substance, contrary to the need for ECHR rights to be practical and effective and not theoretical or illusory. Second, recent Strasbourg authorities underline the ECHR rights may be what they describe as divided and tailored. See, for example, the case of Carter and Russia from 2022, meaning that jurisdiction can apply to some, but not necessarily all rights. See also, for example, the recent case of HF and France from last year, where Article 3.2 of Protocol 4, the right to enter a state, was engaged in respect to French nationals outside of France, but not in relation to Article 3, prohibition on torture. The Grand Chamber pointed to special features in that case when concluding the applicants were within the jurisdiction, in fact, for the purposes of Article 3.2 of Protocol 4. If that's so, is there not a case for saying that somebody deprived of citizenship while outside the country of nationality can similarly trigger ECHR jurisdiction, bearing in mind the ramifications that flow from deprivation? And third, back to the case of Carter. Strasbourg was clear. Territorial jurisdiction cannot be interpreted, to quote from paragraph 128 of the judgment, so as to allow a state party to perpetuate violations of the convention on a territory of another state which it could not perpetrate on its own territory. Isn't that arguably exactly what happens when someone is deprived of citizenship outside their country of nationality, particularly when the timing of the decision is deliberate? It's to impose a barrier on Article 8 protection for that individual. That brings me to the second part of my presentation, the shape of Article 8 when deprivation claims, when it is engaged in deprivation claims. Going back to the Strasbourg authorities, the approach is slightly different to other Article 8 claims. Essentially, Strasbourg applies what it describes as a two-steps test to determine if there's been a breach. First, what are the consequences of the decision to deprive on the individual in question? And second, is the decision to deprive arbitrary? Strasbourg sometimes addresses those two questions in reverse order. See, for example, the case of Begum and France from 2020. Those two concepts, consequences and arbitrariness, are addressed in a number of the cases, and Usmanov and Russia, a case from 2020, is one. Looking at consequences in that case, Strasbourg considered the fact that deprivation left the applicant without any legal status in Russia and without any valid identity documents, which were essential for everyday life there, including for tasks as trivial as buying a train ticket. Such consequences were sufficient to interfere with the applicant's Article 8 rights, so said Strasbourg. In determining arbitrariness, Strasbourg looked at whether the decision was in accordance with the law, whether it was accompanied by the necessary procedural safeguards, including whether there was an opportunity to challenge the decision before the courts, affording relevant guarantees, and whether the authorities had acted diligently and swiftly. On the facts, the court was not satisfied that the laws in question or the procedural safeguards in play were sufficiently clear to protect it from arbitrariness, and ultimately found a breach of of Article 8 as a result. It's worth noting in passing, perhaps, that the concurring judgment of Judge Lemons and Judge Ravanathy, agreeing with the majority, noted that the Strasbourg authorities had been confusing, to say the least, in deprivation cases, in part perhaps because of the two steps approach. They advocated for bringing the principles in line with other Article 8 cases by looking at whether Article 8 is engaged, whether there's interference, whether the interference is in accordance with the law, whether it pursues a legitimate aim, and whether it's necessary, balancing the competing interests. Generally, Strasbourg has considered deprivation through focusing on private life. And family life has only really featured, or generally only features, when there's a subsequent decision to remove or deport, in which case the normal principles applicable in Article 8 immigration removal cases are applied. But bringing these principles back to domestic proceedings, in R3, the Court of Appeal relied heavily on Usmanov to conclude that the focus in deprivation decisions is generally, if anything, private, not family life, with family life only coming into play if there is effectively a decision to remove or an application for entry clearance. As to arbitrariness, R3 argued a number of points, including first, that the underlying power to deprive, Section 42 of the 1981 Act, was not sufficiently clear and precise. The power was extremely broad, and the Secretary of State had simply to conclude deprivation was conducive to the public good. At the time, and even now, as Emma mentioned, there's very little guidance as to what constitutes conducive to the public good in the context of national security, adding to the lack of precision and clarity required for foreseeability. And second, there were and remain a lack of procedural safeguards to prevent the power being exercised arbitrarily. As many of you know, the Court of Appeal flatly rejected those arguments and concluded that the decision to deprive was indeed free from arbitrariness. So finally, what does all of that mean in preparing a SIAC deprivation appeal? Well, we can discuss this, but as it currently stands, anyone outside the UK who's challenging deprivation will need to bring an application for entry clearance in order to potentially bring Article 8 into play. That seems the safest way for now, pending further guidance from Strasbourg or indeed the Supreme Court. Once Article 8 is in play, the question remains to what extent? In circumstances where the refusal of entry clearance, rather than the decision to deprive, is likely to be the focus, albeit that the two appeals can be and often are heard together. Thank you very much.
Thank you, David. So human rights in deprivation appeals are out, which is rather ironic given SIAC was created to protect human rights under the Human Rights Act. So in terms of the metaphor, the target shrinks. You can't even challenge the decision on human rights grounds. So now, can I ask Amanda Weston to talk to us about arbitrariness?
At the bottom of all this stuff is the problem of lack of adequate pre-legislative scrutiny. I mean, that's underlying everything. The reason we've gone all around the houses on the statutes and come up and come down again and had to come up with all sorts of collateral applications and JRs and challenges in order to try and make the remedies effective is because Parliament never really thought about what's the consequence of removing the suspensive right of appeal. I banged on about this for about 10 years, and it's worth saying again, when the suspensive aspect of the right of appeal was removed as a footnote to the 2004 Asylum and Treatment of Claimants Act, ECHR Act, it was on the basis that the government of the day told the House of Lords during the late stage of the passage of that bill that they wanted to be able to run deportation and deprivation proceedings concurrently rather than sequentially. But we all know that that the effect of that is that the procedure became one in which, it's a two-stage procedure, you serve your notice of intention, or under the current legislation you don't need to serve it at all, but anyway, that decision gets taken, that triggers a right of appeal, and then there's a discretion whether or not to serve a deprivation order, to make a deprivation order, and it's the making of that order that renders that person no longer British and unable to access the UK if they're outside the UK. So what Parliament didn't do when that amendment was made was think about what would be the procedural consequences of having a person who has lost their citizenship outside the UK and unable to return. What will be the consequences for the effectiveness of the appeal, particularly appeals in SIAC? Where the question of national security arises, what will be the consequence for a person, as in Begum, who cannot safely provide the information that they want to provide in order to answer the national case? Parliament just didn't grapple with any of that at all. And so the courts have had to. When Lord Reid, I think it's paragraph 62 of Begum, refers to Parliament being silent on those key procedural issues and a institutional reluctance not to fill the gap with a Sims-based common law argument about legality. Because we have to remember, of course, that Begum, one of the reasons why human rights wasn't drilled down into in the Supreme Court is because the Begum Supreme Court case was procedural. It was a common law procedural case. It wasn't dealing with a substantive appeal as such. So that's a mess. That's why we have a mess. We have a terrible mess. Compounding that, we have a situation where Parliament has prescribed, and we keep going back to that in the current climate, it's all about Parliament-made law. Parliament has prescribed that the condition precedent to the exercise of the statutory power to deprive is an evaluation by the elected minister. That's always going to be problematic, and that's precisely why Rehman was pulled in by the Supreme Court. And that's the underlying problem. The 1918 formulation of powers to deprive was much more focused in a condition precedent which was probative by way of fact, such as a conviction within 5 years of naturalisation. So it's the fact that Parliament has provided that effectively the same evaluation that applies to deportation of foreign nationals applies to removal of citizenship. Nick Blake, former of this parish and High Court judge, wrote an article in 2006 when the threshold for deprivation was reduced to the conducive test in the Times, and it was called "Why is no one making a song and dance about this?" Which is still available online. And he saw what was going to happen, and he was right. So then just on to the question of arbitrariness. So what is the current state of play? What's the cumulative effect of all the problems that you've heard about today? Just sort of run through a few of them. I mean, I won't run through all of them, but let's run through a few of them. We've got the low threshold. We've got the vagaries over whether you get any notice of the decision. You've got no prior judicial scrutiny. Ex post facto judicial scrutiny happens possibly years after the event, including the question of whether or not you're stateless as a matter of fact. Whether you're stateless is a question of whether you're de jure stateless, which is an issue determined by evidence of foreign law in this jurisdiction, regardless of what the home state actually says. And that's something that Lord Johnson has described as a fiction. He's right. What else? What else have we got? We've got CMPs that don't function effectively. If anyone's seen the latest Special Advocates blog, Angus McCulloch's blog on this, if you've read Mr. Justice Ousley's recommendations following the implementation of CMPs in civil proceedings under the Justice and Security Act, or for all those reasons, and I could go on a lot just about CMPs, about why they don't work, why they don't function. And then you've got obviously all the problems associated with being outside the country. You've also got no oversight of the exercise of the power. No one is looking at, with those kinds of institutional powers, whether there's a national security benefit to the decisions that are being taken, when weighed against the obviously discriminatory effect that everyone's been able to remark on. I happen to sit on a commission which is looking at this stuff, and so I was interested to hear what Baroness Larcy had to say in the Leader podcast, because she hasn't been so vocal, thus far in the commission, but she has definitely, and we've sat through a lot of evidence, lots of people. The only people that we haven't sat through evidence from is the spooks. Of course, no one's coming to talk to us about that. But anyway, the independent monitor the independent review of counter-terror legislation did come and talk to us, and what he said was that he and his predecessor Max Hill and Max Hill's predecessor David Anderson have all recommended that the oversight powers and function on a statutory basis of the independent review is extended to cover deprivation of citizenship, and the government has refused to do so. So that actually leads into one of the things I'm going to say about why it's arbitrary. There is quite a lot of helpful case law, I won't go into it now, on the question of what sort of features of a legislative framework containing these draconian measures are necessary in order for a state to be able to demonstrate that the measure and the power has sufficient quality of law. And oversight is one of those, which is notably absent. There's been no post-legislative scrutiny of the effectiveness. From a practitioner perspective, it very much feels like the Wild West for the security services. Right, so I'm going to hope that I do this right. Yay! Okay, so let's talk about some law, a little bit of law. So the concept of prohibition on arbitrary deprivation of nationality primarily found in Article 15.2 of the Universal Declaration. It's important to point out that just having a statutory scheme isn't enough. If it were, all the states that are signatory to the Convention would just be able to legislate themselves a draconian power which is completely arbitrarily to be exercised. Oh, that's what they've done. Yes, that would be a way around it, but of course it's not sufficient just to have a statutory scheme. The statutory scheme also has to be interpreted and applied in a way which doesn't breach the principles of arbitrariness. The importance of customary international law. It seems like sort of old-fashioned law now, but I still say, notwithstanding SC and the Supreme Court, still of the view that this is the proper approach in interpreting these sorts of broad powers. That the domestic law should ordinarily develop in harmony with international obligations, and customary international law is in fact part of the common law. So that's why we can't just ignore it. And this is the basic principle of the impact on common law. The presumption is that customary international law, once established, can and should shape the common law whenever it can do so, consistently with domestic constitutional principles, statutory law, and common law rules, which the courts can themselves sensibly adapt. And that is a well-known case of KU. And this applies both to the substantive and procedural law, because of course the arbitrary elements of the procedure that of the process that we've identified apply both to the substantive law, the vague threshold for deprivation, also to the procedures which are available in order to first take the decision and also access redress. I'm not going to go into that. Important also to view discrimination as an aspect of arbitrariness, and discrimination in international law features as an aspect of the prohibition on arbitrary conduct. And then you've got the sort of international consensus. That's a trickier one, but always keep your eye on what's happening in other countries. For instance, the Australian jurisdiction, the common law jurisdiction has recently ruled that deprivation of Australian citizenship is unconstitutional. I mean, it's different for us because we don't have a written constitution. The German constitution, which writes dignity into their constitution, their courts have also come up with some quite helpful constitutional barriers to deprivation. But obviously, where you don't have a written constitution, you're very much forced back onto the principle of legality and Sims, and we saw that didn't do very well in in Begum, because the fundamental problem, we go back to it, is that the courts are driven by what's set out in the statute. I paraphrase Lord Reid, whereof Parliament doesn't speak, the courts aren't going to fill the gaps. Okay, so the bit that I particularly wanted to get onto was the fundamental features of sufficient protection against arbitrariness. So the first is that the decision should be carried out in pursuance of a legitimate purpose. We're familiar with that concept. It should be provided for and in accordance with the law. I've pointed out the point about its compliance with statute law is not sufficient. It should be necessary and proportionate and in accordance with procedural safeguards. So that's the basic sort of fundamental principles of non-arbitrary decision-making in international law. And obviously, the more grave the consequences of the decision, the more important that those particular aspects of international law be complied with. We've got some stuff about there about minimum content and procedural safeguards. These sources of international law are obviously don't carry the weight of international courts' judgments, courts of coordinate jurisdiction, but nevertheless do form part of customary international law and often reflect it. So it's worthwhile turning to those treaty body documents where the application of the concept of arbitrariness has been tested in the context of deprivation of citizenship. What does a fair and independent review in international law consist in? It's a meaningful review of the substantive decision. The individual concerned must have at the very least sufficient information meaningfully to contest the facts and the arguments of the state in court, and the decision-making process must be independent and objective. That, to a large degree, dovetails with the procedural safeguards inherent in where Article 8, where you're within the ambit of Article 8. And there's some other more esoteric guidelines which are apparent from the treaty bodies, which are also worth turning to. The Institute of Statelessness and Inclusion has formulated a set of principles which are available online. They always seem to me like a dreamy wish list made of wishes and cobwebs to me. And I took part in sort of drafting them, and I'm sure they would go absolutely nowhere if you tried to rely on them in the domestic court. But they do give you an idea of a formulation of minimum requirements for the use of deprivation in the national security context. And I've given some further reference documents there. The last point I wanted to make was about arbitrariness in the Article 8 context and the engagement of Article 8. Call me old-fashioned, but it always seemed to me that if the purpose of deprivation was to stop you coming back to the UK, if the stated legitimate aim was to stop you coming back to the UK, then whether or not you had to make a collateral application for entry clearance in order to enter the UK for the purposes of appearing in your appeal was neither here nor there. It seemed to me that that was always going to be something which Strasbourg would say, well, why, if you've got a right of appeal? And if you go back to the circumstances in which the suspensive right of appeal was removed, so what right of appeal, it's no longer suspensive, the justification given by the government at that stage very much was, well, it's not going to affect the appeal rights. And it was certainly, and when we took K2 to Strasbourg, it was perfectly clear that Article 8 was engaged on the facts of that case. Nobody disputed that, because there's plenty of Strasbourg law which supports the argument that where you have a pre-existing private and family life in the state concerned, a measure which prevents your return to it while you're outside the UK will engage Article 8. At the very least, it will come within the ambit of Article 8 for the purposes of engaging those procedural protections. And I've never really understood the formulation in domestic law which says that you only get into the ambit of Article 8 once you've shown that deprivation is arbitrary. I mean, in ECHR and those sorts of cases, there seemed to be a bit of a misunderstanding about the low threshold for getting into Article 8 at all. But we also have to remember that the reason why the entry clearance applications were made in the first place was because the government's response to the procedural JRs for people to return to the UK for the purposes of running their appeals fairly from inside the UK and safely was you've got an alternative remedy. Your alternative remedy is making an application for entry clearance. And from there, once again, lack of legislative scrutiny, lack of a plan, lack of forward thinking by Parliament about going back to Emma's vacuum. Now we've got to the stage where the position of the Secretary of State advanced on the court successfully is that you don't get into the territory of Article 8 at all unless you've made that parallel entry clearance application. And for all the reasons David said, I think that's not going to survive because, as I say, in removing the suspensive right of appeal, Parliament intend that they would also be removing effectively your ability to make a human rights argument for jurisdictional reasons. I just wanted to finish up by saying that one of the things that often gets lost in these very interesting arguments is the people are on the end of the decisions. And one of the things that obviously in the early days of these sorts of cases, in G1, L1 and those sorts of cases, we were definitely in the realms of knowing that our clients had been up to something, but we were running the points in principle. And so those sort of in-principle points and those in-principle battles are now very much turning on, and should be turning on, the facts of the individuals. But the government knew what they were doing when they ran all those cases first. They set down the procedural position and the thresholds for being able to access the UK for the purposes of running the appeal in terms of cases which raised very difficult issues about national security. Now we're in a situation where we're sort of on tram lines and we're going into territory where, according to the principles that those cases set down, we're coming up with some very harsh decisions. And so my advice to you is revisit those principles in the context of the facts of your clients' cases, because increasingly the facts of your clients' cases are quite distressing and in my view, particularly because the Supreme Court has never really looked in detail at a substantive deprivation case. All the appeals that have got to the Supreme Court so far have been largely procedural or turned on statelessness. So those arguments are very much still available to be grown up from seed. We've seen already oscillation in the way that the courts have addressed the procedural matter. So, for instance, initially it was said that the courts agreed with the Secretary of State that the deprivation order process was all part of the appellate process. Then they said it wasn't, then they said it was. And in the meantime, we had to grow up our tactics and our strategy around whatever the current position was regarding whether a collateral JR was going to be necessary. For all the reasons you've heard today, that journey is not over. And so my essential message is revisit those principles and try and grow your cases from first principle if you can, because it's still worth doing on the facts of your clients' cases. Thanks.
Thanks, Amanda. And of course, if we are lucky and get permission to go to the Supreme Court, you three will be precisely the type of case that Amanda is talking about, that was grown up from scratch for exactly the same reasons that Amanda has been talking about.
Compassionate facts, definitely.
Indeed. So that's it. I think we've brought it in within just about 90 minutes. And I just want to do one postscript. And Amanda's already mentioned it. Very recently, the most senior special advocate has said that he is not willing to take any more instructions in closed material procedure cases, which I imagine would include SIAC, because there is a serious resource issue affecting the Special Advocate Support Office at the moment, as found by Mr. Justice Ousley in his recent report under the Justice and Security Act. So if you add to all of these points that the special advocates cannot do their job because they are not resourced properly, then when you ask the question that we asked at the beginning, now I asked it in an anodyne way, SIAC, fair enough? What I should be saying is SIAC, fair enough? And I think that speaks for itself. Thank you all for coming. Thank you all for tuning in. And if anybody can stay for a little bit longer, there's refreshments at the back and we can sit and chat and you can ask questions of the barristers who've been given their presentations today. Thank you all for coming.